Emergency arbitrations, when we first started doing it, we actually had a physical bell that we would ring in the SIC office where people would be running around like it was a movie set and like papers are flying. Is it the speed and alacrity of which a tribunal can review evidence might actually get you to a different decision? Every year it seems like arbitration is at an inflection point and there is a new threat to arbitration. I think there were arbitration purists that were panicking and thinking that this was the end of arbitration, but it turned out to be exactly the opposite.
So we are very fortunate to have with us Mr. Kevin Nash, who's the Director General of LCIA. Mr. Kevin Nash, welcome.
Thanks for having me.
So let me dive right into the conversation. And as we see that generative AI is being used in procedural hearings in arbitration right now. So do you see that institutions would be making guidelines and rules for the restrictions for use of this generative AI?
Well, I think that you have to be doing this as an institution. I always go back to something that the Chief Justice of Singapore said about institutions, that institutions have moved from mere stewards to the true thought leaders in arbitration. So if you look at some of the most important procedural innovations that have happened in arbitration, these tend to emanate from the institution. So I think it's an important question, not just for LCIA, but for all the institutions. And then that question, you can extrapolate it somewhat. Is this something that is going to be hardwired into the rules if we really want these provisions to have teeth? Does it need to be baked into the institutional rules? Or is this something that can be done by way of soft law? So I think that we're seeing very helpful guidance from the IBA, New York Bar, Silicon Valley Arbitration and Mediation Center. But right now, for the most part, I think a lot of this is being regulated effectively in the first procedural order, or sometimes very intentionally not being regulated at all. And we can almost ask ourselves somewhat of a provocative question of whether users are actually expecting that counsel are going to be using AI, that arbitrators are going to be using AI in the same way that we might be using Google, or there would be an understanding or an appreciation that Google is going to be used. What I think is important to do, and I kind of like the analog of AI or sort of as, or similar, I think, in terms of restriction and parameters as tribunal secretary, that we want to establish the guardrails and parameters for the use of AI to make sure that AI isn't impinging or influencing a tribunal decision-making process. I heard it put in a very interesting way by an arbitrator in Miami last year, and his concern about the use of AI is that the speed and alacrity of which a tribunal can review evidence might actually get you to a different decision. His theory was that it's the process of how much time it takes to review the evidence that actually gets him to the right decision. So I think the world is looking to LCIA. I think that we have an enormous benefit of having Professor Maxi Shearer as president of the LCIA court, who is one of the leading voices on AI and legal tech, and the fact that LCIA is known for its academic scholarship. So to a certain degree, I think everyone is looking and thinking, what is LCIA going to do? One of the next steps as well, and we're really trying to canvass the community, is do users want institutions to be using AI? So I have spoken publicly about sort of 3 areas where I think the LCIA can be using AI. That is building a better cost calculator, the appointment of arbitrators to try to remove subconscious bias, and a very live issue right now, the review and scrutiny of awards. Is there an AI tool that can make this better? Many of you might have seen the Global Arbitration Review LCIA hackathon. Some of the entries that we saw there, particularly from India, were absolutely transcendent. When you see what students can do to solve some of the thorniest issues in arbitration, it shows how much can be done with some of these AI tools. And isn't it really a question, or aren't we really trying to get back to the fundamental tenets of arbitration to begin with, and that AI can actually help get back to these fundamental principles of speed, cost effectiveness, all of these things of why we choose arbitration to begin with in an increasingly complex world with increasingly complex disputes? these AI tools might help us get there. So the way that I envision it, when LCIA incorporates some of these AI tools, that it may be the case that we would put it to the parties at the commencement of arbitration to note that LCIA uses AI tools for certain of its case management processes under the supervision of the international arbitration lawyers and the LCIA Secretariat. If any party wants to opt out, or please let us know by date, so then it can be, the parties can decide, even with the very secure AI ecosystem, maybe they don't want to have it for this case. And I think that that's the way that we'll probably design it at LCIA.
So, Mr. Nash, what is NCIA currently have deployed in arbitration, use of AI in arbitration, and what is currently working, and how you are looking at implementing AI into your procedural hearing? And can you tell us a little bit about what other institutions are also looking at?
So I suppose the short answer is that LCIA is not using AI tools currently. We really want to make sure that we get the security and the data protection right. But I do think that some of the tools that are in progress really can improve an LCIA arbitration, and maybe I'll provide a bit more detail on those. And I mentioned the cost calculator, appointment of arbitrators, scrutiny of awards. I think all of these are critically important, and particularly with scrutiny. So LCIA doesn't have a formal scrutiny process in the same way as ICC or SIAC, but I was very pleased when I arrived at LCIA, because I've spent most of my institutional career reviewing and approving awards, that all awards are reviewed and approved at LCIA. But because we have these very good checklists in arbitration, again, at ICC and SIAC, and all of this domain knowledge at LCIA that has been gained over thousands of cases, do we really want to be relying on human international arbitration lawyers to know everything and rely on that institutional memory? Or should awards potentially in a very secure way be run through an AI tool, and then they'll be reviewed by counsel, registrar, and then up to me? I think particularly for some of the jurisdictional requirements. So whether that's interest in MENA, whether a power of attorney has to be issued in Indonesia, whether punitive damages are against public policy in China, many of these jurisdictional specific requirements, these can immediately be ascertained by virtue of an AI tool, and again, then reviewed by the Secretary. The cost calculator is one that I'm quite excited about, and we're midstream and really trying to get this exactly right. And this is almost born of some of my frustrations with institutional arbitration, that I will go to an institution's website and I will try to estimate for my own reference what the fees are, the institution's fees, the tribunal's fees, and you will get numbers that could be gained and gleaned in the same way as if you had a manual calculator. It will say the minimum fee, maximum fee, average fee. But what we want to do is we want to look at thousands of LCIA cases, and that based on inputs, sector, industry, quantum, complexity, that then a user could see prior to filing a request for arbitration, that based on, for example, 116 LCIA cases, this is how much it costs, and this is how long the case took to complete. Because it may not be a very good comparison if you're looking at an average or a mean, if you have a complex construction case or a simple debt claim. These are very different kinds of cases. And so if one of those took 3 years and the other one took 3 months, it doesn't tell us very much if the average is 19 and a half months for those two cases. So I think that's going to help. And then also the appointment of arbitrators. I think that we all have to acknowledge that subconscious bias is real. LCIA has done very well with the diversity of its arbitrators. But for me, having acted as an appointing authority, even the creation of that initial list is potentially susceptible to bias. So if you can again have some objective inputs that you or for the case, and then an initial list of arbitrators, when the institution is called upon to make the appointment, let's say that's 10 or 15 arbitrators, and then again, the international arbitration lawyers, counsel, deputy registrar, me, then it goes to the president and the court, and we vet based on that initial list, but we are not coming up with the initial list, which may be prone or susceptible to subconscious bias. And then also the possibility of an external facing tool. So users of LCIA arbitration can take advantage of this LCIA database of arbitrators that has thousands of arbitrators, and they can input certain aspects of their case and be furnished with an initial list. I think the question for arbitration or sort of more broadly, and institutional arbitration more broadly, is there some sort of multilateral arrangement that institutions could come to help regulate and govern AI? I thought it was very fortuitous timing prior to the COVID-19 pandemic that all the institutions had come together on the SOL protocol and were working together on virtual hearings. You see how hearing centers have reciprocal arrangements on hearings. Is this something that we as institutions could get together on? I think that we should. It is a very live issue. I think that we're fortunate at LCIA to be in the throes of a rule revision process. What LCIA did on council conduct and having it annexed to the LCIA rules, I think was an important step for arbitration. I think council conduct has been previously maybe was the most difficult thing to regulate because, of course, you have a patchwork of different local regimes and how conduct is being regulated by the various law societies, and that LCIA annex on council conduct. So I can see a future where there is an annex to the LCIA rules, the next edition of the LCIA rules on the use and regulation of AI. But I would be even more of an optimist and hope that maybe this is something that the institutions could work together on, because that would be a very significant step. Of course, multilateral arrangements sometimes difficult to achieve. The institutions are talking and looking at what's happening. As I mentioned, I think what Silicon Valley Arbitration and Mediation Center has done is good. I think what the Vienna International Arbitration Center is good. And I can only look with admiration at what the IIIDR has done with their AI arbitrator. And I think what AAA is doing in general on AI has really been first class.
What I can gather from your answer is that institutions require more flexibility with respect to different industries. For example, construction is there. So construction, if a dispute is there, then whatever project is going on is halted. Then every day is quite expensive. So do you think that flexibility can be one of the answers where we can, have with respect to dealing with different industries, where we do not have to go for specific set of rules, but in choosing that flexibility, because arbitration was all about flexibility.
Yeah, I mean, I think if you design the perfect set of rules, it should be able to administer a case that is 2,000 USD or 2 billion USD from any number of sectors. I mean, that is what you're trying to do when you're drafting sets of rules, and also that will work and apply at any number of different seats of arbitration. I've been saying, while I've been traveling through India, that in the last 6 years, LCIA has had 70 different seats of arbitration. And that's why when you're drafting rules, and this will be my 5th set of rules that I've drafted, which is a fair few, you cannot make the language overly prescriptive. You can't make it too rigid, because then it's not going to work across different industries. It's not going to work across different seats. But you're absolutely right. It should be arbitration done properly. Rules drafted correctly should be able to already work across different industries. Now, if we can get an additional flourish by having schedules that help it along even more, great, but it should be able to work on its own.
So at LCIA, do you see that right now you have one set of rules, but if the parties, they want something, the procedural order can cater to it? Is it something that happens on a day-to-day basis? Is it something that arbitrators are okay doing, or the parties agree to it?
So that's a very important institutional question. Some institutions are better than others at saying, what are the provisions under the institutional rules that the parties can derogate from? I think that ICC has made the position clear on scrutiny, that parties are not able to opt out of scrutiny, that scrutiny of awards in ICC arbitrations is fundamental to their case management processes. This is why, and it's somewhat embarrassing to have a favorite legislative provision, but I actually do have a favorite provision under the Singapore International Arbitration Act. It's Section 15 of the Act, because it makes very clear of what the parties can agree to, how the parties' agreed rules interact with the legislative provisions, what happens when it's silent, what happens if it says that, or it doesn't say the parties can otherwise agree. I think this is all very important. What can the parties agree to? And also that interaction between party agreement and the tribunal. What happens if in an LCIA arbitration that the parties agree to 150 days of hearings in a 1 million USD dispute? Because the parties have agreed to that, does the tribunal automatically have to take that agreement? So it is an interesting issue.
As discussed, you mentioned that a lot of sector-specific rules are more or less annexed as schedules. But what if, as we've discussed, if we have separate rules with respect to different areas, for instance, maritime, construction, energy? So can language, as you mentioned, that language plays a very descriptive role. So with respect to making or creating these separate rules, is language a determinative factor covers all the loopholes and contingencies, will that be of effect and efficacy for parties to refer to?
I should clarify, most of what I've done across different sectors have been in one main set of rules. I think that having schedules and separate protocols is something a bit newer. I mean, you absolutely can have separate set of rules. I mean, there's separate set of rules for effectively for space disputes that you see at the PCA. So it's no problem to do so. And that competency issue that I suggested, I mean, this is really just a question of arbitration clause drafting. I mean, for any set of rules, you have to anticipate how parties are potentially going to game it or what's going to happen with loosely drafted arbitration clauses. But that shouldn't stop an institution from introducing a specific set of rules. And I think sometimes having a separate set of rules is better than having an application process in the main set of rules. So if you look at the construction of a lot of the fast track procedures, these expedited procedures, certain institutions will have it where it's a contested application. And so one side will say, we think that this should be expedited, it's very simple. And then the other side, unsurprisingly, will say, no, this is very complicated, and all the reasons why it shouldn't be fast tracked. And then the institution, at a relatively early stage, has to make a very important procedural decision, which could include a change to the number of arbitrators that are being appointed as well. So if you look at that construction, which I think has been very useful and somewhat of a boon for arbitration, versus having a separate set of rules. A separate set of rules, you could almost argue, is safer because there can be no denying, assuming somewhat precise drafting, that the parties have agreed to this separate set of rules and they ought to be bound to their bargain. So I see, or it certainly shouldn't be a limiting factor for an institution. And I think it also brings up a larger question of convergence or divergence. Say, if there's an institution that has a specific set of rules for construction disputes, that then if I'm the owner of a construction company, that I want to use this for my construction disputes because they cater specifically to that. And then there's a different institution, say if it's a corporate dispute, then I might go to LCIA for my corporate dispute because LCIA does a lot of that, banking, financial services, these kind of corporate disputes. And then it becomes a menu of institutional choices. So that's kind of the argument for divergence and not having all the institutional rules being the same. And I think particularly for Indian parties, and that's why I think that we're very encouraged by what you all are doing. I think it's very good to have parties with these different choices and that are just getting used to having institutional arbitration, and then also playing around with the seat and governing law. One of my big points that I'm trying to make in India is that you can use a Delhi seat, having Indian law governing the substance of the dispute. And maybe if you're choosing LCIA as the administering institution, that is going to help you get these very important elements, that you're keeping the seat in Delhi and you're getting India as a governing law. So I think it's overall a good thing and not something that should prevent a choice being made to have that separate set of really kind of bespoke rules.
You've been to so many jurisdictions and had your experience across Singapore, London, and I'm sure you travel and you've seen arbitration and the ADR landscape in different countries. If I were to ask you from a cross-cultural point of view, what is the difference you've noticed or witnessed in different jurisdictions amongst people?
I mean, no, the easy answer to that always becomes or discovery, and everyone in arbitration, we're always so concerned about discovery. And what I actually find quite funny, say, discovery, which is a creature of the American system, is that we actually have a more palatable term for it in arbitration, that we don't want to scare anyone, so we call it document production, not discovery, which is functionally the same thing. I actually think, at least in international arbitration circles, that there are not that many differences, and what I tend to see is similarities, and particularly this idea that there's a divide between common law and civil law. I don't think that is actually made out in practice. I think that there is almost like a legal tradition of international arbitration. But it's important to not just sort of immediately, like I just said, that everything is quite similar, everything is the same, because I think it matters when you're appointing arbitrators, because the kind of arbitration that you are going to get depends a bit on the background of these arbitrators. There's this great concept that's called the domestication of international arbitration. So if you had, say, a dispute involving a Japanese party and an Indian party, and LCIA was the administering institution, and we appointed 3 retired English judges or 3 very senior barristers, that is functionally becoming, or will be run, presumably, a bit like a domestic English arbitration. So there's a question, do we want that for the dispute? So even though there's similarities, you have to be mindful of some of those differences, because how the case is going to be conducted is going to depend to a certain degree on the background of the arbitrators.
So let's just steer the conversation to another aspect. So we've discussed the institutional aspect, the technology part, and the industry specific. So a very important part of this conversation is the business, who are actually opting for arbitration. So we are facilitating arbitration for them as institutions. So because we've seen the new generation of business leaders as well, who want these disputes to go away really fast. They want this, they don't have the patience to actually lead long procedures. How are we going to keep up with them? And how are we going to, cater them with their patience level? Or do we have to teach them that impatient cannot be the answer for a dispute resolution? Or is it moving more towards an international arbitration also? We've seen a move toward parties taking the way of mediation as well. What do you think about that?
Well, I share the impatience of some arbitration users. And I think that particularly for Asian arbitration practitioners, we like to move very, very quickly. So I don't mind when new arbitration users want things done very quickly, because there is prejudice that will accrue in certain cases, like where you need an award in 6 months. I think that's why I've designed and constructed expedited procedures, super expedited procedures, and that is starting to be like a proper thing in arbitration. One thing that I'm trying to do, and I'm hoping to do this year when releasing the LCIA statistics, is a few things that I think helps new arbitration users, and that is publishing the institutional timelines. Yeah. So all the institutions publish what their average timeline is. So this is how long it takes us to conclude a case. This is the median time. This is the mean time. But similar to what I was talking about with the cost calculator, that doesn't really tell me anything as a potential user. So if an institution told me that their average time to conclude a dispute was 3 months, I would say you probably have a lot of small and simple cases, because 3 months doesn't necessarily say what the efficiency of the case. I mean, efficiency needs to be compared to something. It needs to determine whether or not it is efficient. So what I want to do is publish the institutional timelines, because I think that's what parties are really looking for, because you're trying to cater to the expectation of the parties. So how long does it take the institution to answer a request for arbitration? How long does it take to deal with a composite request or a request for consolidation, appointment of arbitrators? How long for the award to be rendered by tribunals after the hearing or post-hearing submissions? I think these are what we need to publish. And I often say, and it really sort of informs my case management philosophy, is that we are appealing to the first-time arbitration user. It's almost an audition of arbitration. It is the future unicorn. I think how an entity or a company that has been using for arbitration for 40 years, they will have a certain cynicism of arbitration in the same way that I do and all of us, is that we understand arbitration sometimes doesn't meet what it is designed to be, and it can be a little bit more expensive or take a little bit longer. But I think that first-time arbitration users have absolutely no tolerance for this, and they will very quickly go to a different form of ADR. So I think it is incumbent on all of us to really make sure that we are delivering that promise of arbitration. And one way, to your question, that I think that we can help deliver that is not being, it almost sounds counterintuitive, but not being so fundamentalist about arbitration. So you were talking about mediation. I think mediation gets along very well with arbitration. So I prefer having it styled as arbitration, then mediation, then arbitration, but mediation and arbitration, leaving aside a certain academic issue under the New York Convention or potential issues with limitation, works very well. Chinese parties have been using MedArb to, I think, astoundingly good success for a long time. And then I think also institutions publishing in support of mediation or these different forms of ADR, publishing the settlement rates. I think every institutional representative would understand that whether it's 1 in 2, 1 in 3, 1 in 4 cases is going to settle. Yeah. If I was the GC of a company and this was my first arbitration, I would really want to know this, that effectively, there's a 1 in 3 chance that this is probably just going to go away and we're going to be able to settle, especially if I'm on respondent side and I've just eaten a notice of arbitration. I would want to know that settlement is possible here, and that we don't necessarily have to go all the way to a final award where I'm going to have to pay lawyers all this money. So I think it is really important for institutions to do.
You said that they can save the money and they can save the time with respect to using the hybrid of mediation, arbitration, arbitration and mediation. We've seen that a lot of people are using ODR as well. ODR is now one of the players that used to reduce the time of arbitration. Do you think that ODR is going to play a catalyst role in this? Because we are seeing the use of ODR across, like India is quite, it's not as advanced as foreign jurisdictions, but it is right there. And we are using ODR, like we are relying on ODR. Do you think it's going to play a catalyst role in, achieving the expectation of these business leaders who want quick resolution?
Especially in a jurisdiction like India, where you have so many cases and so many disputes, you have to have an institution like yours that is able to have this kind of offering. But there's also, I think, some of the learnings from ODR can be used in very high-ticket, complex arbitrations where it's not functionally an ODR process, but there's lessons that can be learned there. And I think that going back to what I was mentioning about the Seoul Protocol, I think that what happened during COVID for arbitration has made arbitration better. It has made it much more cost-effective. There used to be this idea and this sensibility that was very irritating for arbitration users of having to fly out for a first CMC, that you would incur a lot of unnecessary expenses. And the fact of whether or not, say, you're having a virtual hearing, but the fact is most procedural applications, or say if it's a jurisdictional hearing, will be done virtually, and then merits will be done in person. And so it's almost like ODR becomes a testing ground or a laboratory that is going to resolve some of these smaller disputes, which is very necessary, critical in a case or in a jurisdiction like India that has so many disputes. And then some of the techniques that are developed there can then be applied in your more traditional arbitration. So I think it's great.
So Kevin, India has adopted emergency arbitration as far as Indian seated arbitrations are concerned. However, the situation is not the same for foreign seated arbitration. As LCIA and as an institution, where do you stand on this, and what is the way forward?
Well, where LCIA stands, maybe where I stand, is that India has been an absolute boon for emergency arbitration. I think that, and when I was in Singapore, having worked on HSBC, Raffles Design, Hotel Mumbai, and Amazon, this has been so important for emergency arbitration at large across all of institutional arbitration. So the enforcement regime, whether you're under Section 9 or Section 17 in India, whether it's seated in India or foreign seated, I still think that the enforceability of emergency arbitration orders and awards in India is much better than in other jurisdictions. And effectively, the answer used to be for emergency arbitration is voluntary compliance, which is not the most satisfying answer for a user, that effectively you're going to have to rely on voluntary compliance. The hope is that you can actually, eventually this will be given statutory teeth. And because we saw the difference in Singapore, and sometimes I like to see the push and pull of institutional provisions versus legislative provisions. So SIC introduces the emergency arbitrator provision in 2010. Singapore follows in 2012 by providing for the enforceability of emergency arbitrator orders and awards. And then, as was subsequently clarified, even though it didn't need clarification, this applies to both Singapore-seated arbitrations and foreign-seated arbitration. This was critically important. And now I think the same has happened in the English Arbitration Act, is that you now see some statutory effect to emergency arbitrators. And so I think that we'll see in LCIA arbitrations.
So the emergency arbitration, it brings out a very relevant question at this point of time, is with respect to the geopolitical situation that we are facing right now. So we do not know what next month is going to be for the whole world. How do procedures like emergency arbitration, or are we even ready for these kind of situations, and how institutions are going to react to such situation, geopolitical situation, where it's going to affect the businesses?
To me, it's these situations where arbitration shows its strength, and I think arbitration was absolutely critical during the COVID-19 pandemic of dealing with these disputes and dealing with them quickly to keep supply chains open and to keep global commerce operating. What we saw during COVID-19, and I think what we'll see in some of the current situations that we have happening in the world, is you're going to see a lot more use of early dismissal, early determination. Effectively, these common law litigation creatures of summary judgment and striking out, these become very important because there are any number of disputes where it's just a question of the contours of the force majeure clause. Does this force majeure clause provide for a global pandemic? Does it provide for missile strikes or drone strikes? Does it depend on whether there's been a formal declaration of war? These are very important. You have the respondent side is not denying that there was non-performance.
Yeah.
They're saying we didn't perform our side of the contract because there was a lockdown or because there was this conflict. And so being able to deal with these quickly, very important. And that's where arbitration, I think, like I said, really shows its strength, is these kind of situations.
So does this also going to affect how we are going to draft the next generation of our arbitration clauses, and how is going to affect the contract drafting? What measures can we take? Obviously, we cannot foresee, but are there any measures that we can take to avoid these kind or deal with these kind of issues?
Well, I suppose it depends what side of the contract you are on. There are some contracts where you would understand if any side is going to be the breaching party, it will be this side of the contract. I think surely more care when you're drafting in terms of risk management and some of these core clauses that you have in contracts over and above the dispute resolution clause. I think that is obviously important. But of course, you're also dealing now, I think, at least at LCIA, I mean, you're dealing with parties, sanctioned parties. And I think what's important, because LCIA has a very significant amount of disputes with Russian parties from Belarus, but there are also many Russian parties on the claimant side of the equation where you may have a non-performing Western European party that is using the presence of sanctions to get out of a bad deal.
Yeah.
I think so. The ability to have this dispute resolution mechanism that parties from around the world can resort to in times of crisis, very important, because the same way that sometimes the COVID-19 pandemic may prevent a party from performing or encourage a party that doesn't like the deal to not perform, the same can happen with sanctions. So you need to sort of give effect to both the claimant and the respondent side. So I think the ability for institutions to deal with sanctions, which actually was a nice tripartite arrangement in 2017 when LCIA, ICC, and Stockholm drafted a tripartite note to indicate the ability of institutions to administer disputes involving sanctioned parties. That was an important point for institutional arbitration.
So the 2024 arbitration bill is right around the corner, and it is finally codifying emergency arbitration. Now, around the globe, there are multiple jurisdictions where emergency arbitration is already codified. What are the best practices and certain clauses which we can incorporate in the 2024 bill, which will make it more robust?
That's a great question. I mean, what I like about emergency arbitration and what is important is that it keeps parties in the arbitral process. What we don't want in arbitration at any stage of the arbitration, if you don't have to, is parties running to court. So emergency arbitrator provisions are designed to work in a complementary fashion for applications to court. And sometimes you would even see this, and I've seen it in Singapore, having done a couple hundred of these, where you might have one of the heads of relief or one prayer, you will make an application to court. So if we need an order against a third party, so an emergency arbitrator doesn't have those powers of imperium, so that application goes to court. And then the other applications can go, if you have a valid and existing arbitration clause, to an emergency arbitrator. I think there's a case called Gerald Metals in the UK that shows that you cannot be forum shopping, you're not able to take a shot here and there, and so we're going to go to court, we're going to go to an emergency arbitrator. But I suppose the beauty of an emergency arbitrator provision is it doesn't require any specific drafting at the contract stage, because you can never really know whether or not you're going to need resort to an emergency arbitrator. One thing that I've been saying, and I think it's a relatively interesting institutional provision, is the fact that LCIA has expedited formation of the tribunal. Because sometimes when I'm lecturing on interim relief or emergency arbitration, I will just put forth the proposition that if you have a sole arbitrator tribunal, do you really need to have an emergency arbitrator? In effect, what you could do is, if you were the moving claimant and you needed to make an application for urgent interim relief, you could say to the institution, it's a sole arbitrator tribunal, you could file your notice of arbitration, and you could say, here are all my deposits. The parties are never going to come to an agreement on a joint nominee for a sole arbitrator. There is some urgency attached to this case. We would request that the institution abbreviate the time for the respondent to provide a response to the notice of arbitration and proceed with the appointment of the sole arbitrator forthwith. And you could probably get a sole arbitrator tribunal up maybe in 10 or 12 days, depending on the institution, without going through that intermediary step of an emergency arbitrator. What expedited formation does at LCIA, which really there isn't another provision like it in the institutional space, at least what I've seen, is you could get a 3-member tribunal all appointed in 2 or 3 days.
Yeah.
So, and then you can make that application for urgent interim relief to the main tribunal, because when you have an emergency arbitrator outside of, to me, what are pro-emergency arbitrator jurisdictions like India and Singapore, in any other jurisdiction, your mileage may vary on what you're going to do with that emergency arbitrator order. And if you don't get the voluntary compliance, you are going to have to carry that emergency arbitrator order to that foreign court, who may not give effect. You would hope that you would get relief in the same terms as the emergency arbitrator order, but you might not. And this is all accruing time. So the ability to have that 3-member main tribunal under expedited formation, where again, the main tribunal is either going to vacate, modify, or perfect that original emergency arbitrator order. So you're gonna have to go to that main tribunal anyway. So I think that's an interesting option in LCIA arbitrations as well. But I will say, in terms of the Indian legislation, I have seen how much difference it has made when you provide for the enforceability of emergency arbitrators. The experience in Singapore should be very instructive for India, because this has been an absolute success for Singapore, where there is now a culture of emergency arbitration, because it's not just SIAC arbitrations, it's ICC arbitrations with a Singapore seat. We used to have emergency arbitrations. When we first started doing it, we actually had a physical bell that we would ring in the SIC office, where people would be running around like it was a movie set, and like papers are flying, and just because this was so new, it's an emergency, and so new and exciting, we'd be working through the night. I have stories about falling asleep in my chair at 5 a.m, just because it was all new. But SIC has done so many emergency arbitration. That process is really streamlined and fine-tuned. And in Singapore, there is really a culture of emergency arbitration, because you have our Singaporean arbitrators. They've sat as emergency arbitrators so many times. Council have run emergency arbitrations so many times, and it has made a big difference to the jurisdiction. And I think that is the power and really the forward thinking of the Singapore government in terms of getting that legislative provision in place.
So, Mr. Kevin, you've been part of major institutions. You're currently heading LCIA. And in your institutional experience, you've been to India numerous times. You've seen the Indian scene change. Where do you see the Indian scene right now, and where do you see the future of Indian arbitration scene?
Well, I've had the very fortunate experience of being able to be at the top of 2 of the major institutions, which I don't think has been replicated before. And I think it gives me a very good aerial view of what institutional arbitration needs. And through both those institutions, of course, I've been taking many trips to India. For me, India is maybe the most dynamic and important arbitration jurisdiction that we have of all of arbitration. And it's also the room for growth as well. There's this statistic, and it's probably outdated, about how India mints 1 million new engineers every year. Like, that is at a scale that other jurisdictions cannot compete with. So what are we doing in terms of building India as a destination for arbitration? So I was speaking yesterday at the LCIA conference about the London centenary principles that have since been updated and supplemented by the Hawar principles. I'm a member of the Hawar circle that is sort of giving effect to these principles from 2015 in 2025. And if you look at the pro-arbitration jurisprudence coming out of Delhi in particular, Delhi is a good seat of arbitration. So I am able to encourage parties, and I think that's part of the argument for using the LCIA rules. Use the LCIA rules, and the party from North America, South America, Europe is going to be comfortable with that. And then you can get the Delhi seat, and then you can get India as the governing law of the contract. But I do think that the aspiration should be even higher. Yeah. It's not just keeping Indian disputes home, it's getting disputes that have no connection to India. So from MENA, from Africa, from Central Asia, that we need everyone involved in Indian arbitration. That's counsel, arbitrators, institutional representatives, to be going around the world and to be talking about the virtues of Delhi as a seat. And we went through the same progression in Singapore. And the most satisfying cases for us were cases that had no connection to Singapore at all. They were choosing Singapore and SIAC because of the strength and safety of the seat, the precision or language of the SIAC rules. And that was how they were choosing it. And of course, with a seat of arbitration, as you know, you would very much like them to have the hearing or the venue in Delhi, but not necessary. So you could have these parties from Central Asia that have Delhi as a seat and that are using, say, you as the administering institution, and they never have to come to Delhi, of course. we would encourage them to because it's very fun
Yeah.
to come to Delhi. And there are any number of reasons of why you would want to come here, but you don't have to. And I think that is the future for Delhi. And I think what you have to do is you have to really be crystal ball gazing 5 years and 10 years and getting all of these things in place. But it is really important to the thousands of disputes practitioners here. Everyone needs to be aligned on the importance of this. And it's also important to India as a country. There's a lot of surveys that you see. There was one that was done for Toronto in 2011 about the economic impact to a country just by having arbitration. UK has done it as well. And of course, there is no disputes ecosystem that is at the size of the UK, but there's also the soft factors and the optical benefits that you get in terms of increasing foreign investment and getting foreign companies more comfortable. So it is an important thing, and that is my vision for Delhi.
So Kevin, talking about young ADR practitioners, many of them are transitioning from litigation to ADR and arbitration. So what are some of the 3 top resources or platforms that you would suggest them to, for knowledge purposes, just to tap into and learn about it?
Well, there are endless resources. I've had a few conversations with deputy counsel where I've told them that there is about 80 or 100 arbitration cases that you just have to know. And there's no way around it. In order to be able to do this job properly, you have to know all of those cases. But I think that arbitration is ultimately a 50-year career. It is one of those very unique practices of law where you are getting even better as you age through your career. So I do think that there needs to be a bit of patience attached to an arbitration career, because sometimes I'm talking to students and they're in their 4th year of law school and they've already decided that they want to do treaty arbitration and only treaty arbitration. I like ISDS, so I'll often be encouraging Indian students in particular, because of the experience and the benefit that you get of operating in the Indian courts, that litigation and arbitration, it's very transferable. Ultimately, arbitration is procedure, and the experience of doing litigation in India and then maybe starting to transition over to arbitration, there is nothing wrong with that. And I think that it's actually a benefit. Ultimately, what you want to have is you want to have your substantive bona fides and your procedural bona fides. And that is going to include litigation. In terms of the oral advocacy of Indian lawyers, nothing like it, right? I mean, it's the best in the world, and it is very unique in the world of advocacy. So students and young lawyers are going to get a benefit from being up on their feet in court, and then sometimes they can start sitting down and being in an arbitration hearing room as well. And I think we shouldn't really be looking at one path to success in arbitration. I think that my arbitration journey and a lot of my peers and colleagues, it's never exactly how you think it is going to go. And I think you should just be open to the opportunity. And when you get an opportunity, you want to excel at that opportunity. You want to do well and show up, but it probably won't go the exact way that you think. And that's part of the fun of having, say, a 50-year career in arbitration.
Being the representative of an LCIA, what would be your message to the arbitration community here in India and globally as well? Like, what should we aim for? What is the next thing that we need to look out for in arbitration?
To me, I am ultimately an arbitration optimist.
Yeah.
And I will sometimes make the joke that every year it seems like arbitration is at an inflection point and there is a new threat to arbitration. And I will tell the story of 2014 in Singapore with the introduction of the Singapore International Commercial Court and the Singapore International Mediation Center. I think there were arbitration purists that were panicking and thinking that this was the end of arbitration, but it turned out to be exactly the opposite in Singapore. So we then put together the arbitration protocol. This actually turned out to be a very good thing for arbitration, where we've started to use these preconditions to arbitration with mediation or periods of structured negotiation, and we found a way to get the enforceability of those mediated agreements that ended up coming into form with the Singapore Convention. So it turned out that was not a threat to arbitration. And then the same thing as the Singapore International Commercial Court and the prevalence of international commercial courts generally. Now all of a sudden, especially when they're starting to follow the transnational tradition on costs and can award costs more like an international arbitration tribunal. But it turns out the Singapore International Commercial Court also very good for arbitration. You can designate the SICC as the curial court for your arbitration. So if you're not satisfied with the already very pro-arbitration bench of the Singapore High Court, you can choose the Singapore International Commercial Court and its bench of international jurists. And I think This is part of the reason why the New York Convention is probably the most successful treaty that we have in the world, because there are certain fundamental tenets of arbitration that are very difficult to match. So the speed, flexibility, cost effectiveness, this idea that you can choose your own judge, confidentiality, limited avenues of appeal, and then most importantly, the enforceability under the New York Convention. This enforceability and having awards that can travel has not been able to be matched, say, by the Hague Convention or trying to sue, say, on a judgment debt. This enforceability just by itself is why arbitration is always going to remain important. And I think in 2026 and in times of some geopolitical turmoil, I think it's important to show the world that you can resolve disputes peacefully. Like, this matters for more just than the economic interests of companies. It matters for how we interact in the world. And I think from that standpoint, arbitration is setting a very good example.
So we were delighted to have you, Mr. Kevin, at IIDRC, and thank you for being here at the podcast. Thank you so much.
Thank you for having me.
It's been a pleasure.
Thank you.